Good morning, Your Honors, and may it please the Court. James Martin, for the appellants, Energy Transfer, the ERISA plan, and Blue Cross Blue Shield of Texas, the plan administrator. This appeal arises from acute inpatient hospitalization psychiatric care given at the Menninger Clinic for a young woman who was in need of immediate psychiatric treatment. She received that treatment, and fortunately for her, and importantly for her family as well, she recovered. All the parties agree here that psychiatric care was required and that it was beneficial. But the issue in this appeal is different. The issue concerns coverage under an ERISA plan and whether or not 55 days of acute inpatient care was required to treat her condition, or whether, after her initial hospitalization in acute inpatient treatment, a step-down level of care was possible. Now, a step-down level of care does not mean no care, it does not mean no monitoring, and it does not mean no patient attention. What it changes is the circumstances in place where the care is delivered. Residential care, for example, a step-down care, can be 24 hours a day in terms of patient monitoring. And there are acute outpatient services provided as well. So the key here is, was the acute intensive hospitalization care medically necessary as the lowest level of economical care available under the plan? That's the definition, which the court can find at ROA 195.
So how does this work? What is the company or the plan offering for after February 10th? Are you offering just a lower level of compensation, or are you offering no compensation?
What would happen after February 10, Your Honor, is that the plaintiff and her family would be given the choice and the option to go to a step-down level of care. And they were advised on February 8th that they had that choice, and the plan, of course, would have assisted them in finding other facilities that were in network and would have provided the step-down care under the plan. And they were advised of that orally and by letter. They made the choice, which they had the option and right to do, to stay at the Menninger Clinic at the acute intensive hospitalization benefit and to appeal the decision that Blue Cross had made in its discretion, to say, no, we are not going to pay at that level, and they were advised of that. So what the plan does at that point is it's not going to be paying for the acute care that is sought by virtue of this appeal because it's not covered under the plan.
Right, but is the company, is Blue Cross willing to pay a lower amount to cover what they would have been willing to?
It certainly would have paid that amount if the plaintiffs had sought that care, Your Honor, received that care.
But as of now, it's not offering anything at all?
It's not, but it's not trying to collect anything either. Menninger presented it with a bill for $37,000 for the 36 days of care, and Blue Cross said it was not covered.
I guess what I'm wondering, though, is if you're acknowledging that they were entitled to something, not the acute inpatient, right, but some lower level, does the law require you to offer at least the compensation level appropriate to that lower level of care that you acknowledge was required?
Yes. The law does not require us to provide the compensation for the care at that level when the care wasn't given and received and is not being requested as a benefit to be delivered under the plan.
Okay.
That's, I'm sorry, Your Honor, excuse me. That's expressed in the contract, the coverage benefit plan. So, of course...
I'm sorry, you're saying there's a provision in the contract that specifically says if you don't take the level of care we're offering, you'll get nothing?
Yes, it's in the...
Can you give a record site? And if you don't right now, that's fine. You can mention it on your rebuttal time.
I think it's ROA 195, Your Honor. We'll provide that. But the important point is had that step-down level of care been sought, then an evaluation would have been made, and of course, treatment, and the benefits could have been paid.
You understand the spirit in which I'm asking it, right? It does seem like somewhat harsh justice if there's a dispute about the appropriate care level, and if the patient elects to do the more intensive care for them to get nothing, if that's what the law requires, so be it. But it's not normally how we think of damages.
Yes. Your Honor, I think that's the decision this court faces in every ERISA benefits case where benefits are not advanced under the contract. And we see that in the court's cases from beginning to end where discretion is exercised and the plan says no. Then there's an appeal, which there was in this case, and there's a dispute about how or whether the discretion was properly exercised. And at that point, then, the contract just delivers according to its terms. As far as the harshness, Your Honor, had the plaintiffs acted to seek the step-down level of care, there'd be no harshness at all because it would be paid for under the terms of the plan. And we're not begrudging their choice. It's just that the contract can't pay benefits at that level, or the plan couldn't be administered in any kind of sensible fashion. Now, in terms of...
Counsel, if before we leave that thought, February 10 was the cutoff date. Now, that's the date after it was appealed, actually, so that's the extended cutoff date, right?
Yes.
So why February 10? I mean, even the independent examiner didn't really state any reasons for why February 9th was covered, February 10th was covered, but not February 11. So was he just splitting the baby? I mean, that's sort of how it comes across in the record.
Your Honor, there is rationality to February 10, and it does appear from the record, I think, when that's looked at contextually. And let me make clear that in evaluating the selection of February 10, we are applying the standard that this court uses on its review, which is a medical judgment. So, is there more than a scintilla of evidence that supports the selection of February 10, and then the decisions of the 4 independent physicians who reviewed this, which support February 10? Now, I could make an argument that under the court's case law, there is much more than a scintilla that supports that. But looking at the 10th specifically, first, it's important to note that Dr. Gerges, who selected the 10th, which gave 5 more days and now a total of 15 days of acute inpatient coverage, made an evaluation independently to stretch to February 10. So there was nothing random about that at all. He made an evaluation and said, I'm going to give 5 more days of care based on what I have reviewed.
But he didn't explain why, correct?
Well, but Your Honor, as the court knows, under its case law, he's not required to. He doesn't have to give the rationale, but let's again look at the record and see what markers there are that would support that. First of all, you had her entire care as delivered from February 1 up to the 10th. And the record shows there marked improvement. Those are notes in the record, in the hospital records, February 2nd, February 5th, February 7th, and finally up to the 10th. And the 10th was a marker because at that point she was alert, goal-directed, taking care of herself, engaged. There had been no suicide attempts, no suicidal intent, no risk of self-harm, and indeed by the 10th, the record says there was no safety risk at all. Also by the 10th, the anxiety that she was experiencing had nothing to do with suicide. Now, to the 10th and further, so I mean there's context to pick the 10th, the record notes reflect it. Menninger specifically determined on February 10, MP requested a lower level of responsibility from 1 to 2, meaning she would take more responsibility for her care. And on the 10th, Menninger granted that. So on the 10th, she assumed more responsibility for her care. And again, the reason they did that is she was compliant with her treatment by the 10th. There was no need for crisis intervention on the 10th that needed 24-hour care. And finally, there was nothing about her psychiatric disorder at that point that required MP to be at the more intensive level. Beyond that, on February 8th, her treating physician at Menninger, Dr. Davidson, after consulting in a peer-to-peer review with Dr. Krajewski, the psychiatric director at Blue Cross, said, as of the 8th, I don't think she's probably in need of acute care.
Wasn't the 8th when Menninger had requested the extension through the 10th?
Yes.
Did Menninger request any further extensions or coverage after the 8th of February?
Not until the appeal was taken.
Not until the end. Not until,
Yes.
in other words, she had stayed till the end of March.
To Your Honor's point on the 10th, contextually, Menninger had made its own concurrent review on February 1 and said contemporaneously, we think the 10th is where we need acute care to. So in terms of the rationality of this, does it rise above a scintilla that Dr. Gerges could look at all of this and select the 10th? Well, most certainly he could.
Counsel, can I pause you there? I want to understand the standard of review. So, more than a scintilla, substantial evidence, abuse of discretion, arbitrary and capricious review, these are all concepts that we apply with some regularity in other areas of law. I'm thinking in particular of administrative law. If we were looking at an administrative decision from an administrative agency, we often review for the same sorts of ideas. Is your position that we apply the same standard of review to an ERISA plan that we would to, say, the Department of Labor in their decision-making with respect to an adjudication, an administrative adjudication?
Your Honor, I would say that the court should follow the path in applying the standard of review that it has applied in ERISA benefit cases specifically, beginning with the Vircher case, going through the Killen case, up to the Cooper case, the Foster case. What is that?
I'm sorry, I just want to be, before we, I want to hear your answer. I just want to make sure I understand.
Yeah,
Is it the same?
I'm finessing, and I'm sorry, because I'm not sure that if I concede an analogy to Department of Labor review, I'm giving away something that I get under the court's very specific standard of care for benefit cases.
Well, let me ask it this way. So substantial evidence review, abuse of discretion review,
Right.
and arbitrary and capricious review, if an administrative agency is before our court and they were to say, well, we don't have to give an explanation for that, well, that would lose. It's also true if an administrative agency came in and said, well, it's substantial evidence, which means more than a scintilla, and that's
Right.
true for all sorts of administrative review challenges. It is incumbent on the decision maker to offer reasoned decision-making and also to consider evidence that takes away from the weight of the decision that the decision maker makes, which I understand in your response to Judge Wilson, you don't think BCBS has to do under ERISA.
No, under ERISA and this court's precedent, they do not.
So it sounds like the standards are different. I don't mean to put words in your mouth. Feel free to tell me if they're...
It's what the court pays attention to in determining whether there is a rational link to the record.
Am I limited to the decision documents that BCBS sent to the insured?
And I'm sorry, I missed that. Could the court repeat it?
I'm so sorry. Am I limited in understanding how I'm supposed to evaluate the substantial evidence, abuse of discretion, arbitrary and capricious review? Do I look the way I would in an administrative review challenge at just the decision documents that you sent to the insured?
So in the ERISA context, benefit context specifically, starting with the U.S. Supreme Court's opinion in Black and Decker and working through every one of this court's precedents, what Your Honor looks at is the evidence in the record that is favorable to the decision that the administrative plan made.
And ignore everything else?
Yes. And that is specific in terms of this court's precedents. Blue Cross doesn't have to give special deference to the treaters. It doesn't have to give deference to any of the record facts. What the court does is extract the record facts that substantiate the decision. The Black and Decker case from the U.S. Supreme Court, the Anderson case from this court, the Corey case from this court, the Vircher case from this court, the Killen case from this court do that. And the issue is, are the reviewer's opinions rationally connected to the record? If they are, no further inquiry is required. And again, Black and Decker says that includes not explaining away other opinions. Anderson says that again. This court did it. Corey, this court's opinion, says that. Gothard says that. Vircher, as I mentioned earlier, says that. And Killen says that. So I think I'm in firm footing, Your Honor, in making that evaluation in terms of how the court looks at whether there's substantial evidence. Again, more than a scintilla on the path of rationality, even if at the low end. That's all that it takes to affirm. And of course, that is met here in terms of the decision, and that's why reversal is required. I think I'm at the end of my opening bell.
Thank you. You've reserved 4 minutes for rebuttal. I'm going to take the risk and try to pronounce Mr. Sudduth. Sudduth?
I've heard far worse, so no worries. Sudduth.
Sudduth. Mr. Sudduth, we'll hear from you now.
Good morning. May it please the court. Your Honors, I think a brief factual context is important in this case because of just how unique and extraordinary these facts are. But before I do that, I want to answer a couple of questions that Your Honors had from my opposing counsel. First, Judge Ho, you asked about the harshness of this and whether or not there'd be any payment. The simple answer is no. There would be no payment. It's also important to note that managers under this plan was considered an out-of-pocket or out-of-network provider. The total charges to the family were about $80,000. Only $37,000 of the $80,000 is at issue. The $37,000 was paid or had to be paid by the family.
So you're acknowledging that if it turns out that the plan's decision is found to be substantially supported, then your client is not entitled to any lesser amount?
My client, if the court finds that there was substantial evidence, my client would not be entitled to anything. If this court affirms the district court, my client would only be entitled to $37,000 of the $80,000 because that's what the contract or the plan calls for an out-of-network provider. To answer your question to that, Judge Wilson, you asked a question about the rationality on the 10th, and I'm glad you did because Dr. Gertis's opinion as the independent review officer here is somewhat difficult to deal with because you read it and it reads as though a story of why this was absolutely necessary for the entirety of it, and then at the very end, with absolutely no explanation, he only extends for 5 additional days. And this is why the 10th is important, because counsel struggled to explain why the 10th is not arbitrary, but let's look at the record on the 10th. This particular patient came in, and always came in, with mainly passive suicidal ideations. She had those on several occasions throughout managers. On the 10th itself, she was having passive suicidal ideations. Now, why is that important? It's not an active ideation. She's not actually cutting herself, but this is what the defense overlooks in this case. This particular patient had several comorbid disorders that makes her particular condition unique, one of which is she struggled with severe impulsivity. By her own admission, none of these prior actions, five prior attempts over a year and a half of suicide attempts, none involved active planning. They had no forethought. This is what Dr. Davidson talks about when she says it made MP's treatment decidedly more complicated because not only did she have profound depression, but something that the defense fails to mention, which is a patient risk. Under the MCG is a patient risk. She had a comorbid substance abuse disorder.
But what about Dr. Davidson's statement on February 8th that she probably didn't meet acute criteria?
Yes, Judge Wilson, it's very important to distinguish that question because the question, or what Dr. Davidson said was not that she didn't think she didn't need acute criteria. What Dr. Davidson stated was on the 8th, if we're applying the MCG on the 8th, it would be likely at that time in a snapshot that at that moment she might not have met the MCG. What is important...
Well, but all of these things are snapshots, correct? I mean, in other words, Menninger asked for 5 days extension initially, and it was granted till February 5th or whatever day it was. Then they asked on February 8th for 5 more days through the 10th. That was denied. But again, Blue Cross Blue Shield says there's substantial evidence to support those determinations, and isn't that all they need?
All they need is substantial evidence. Yes, Judge Wilson, that is correct. However, it may have been a snapshot on the 8th, but when Menninger appealed the entirety of the denial, that's the opportunity, and that's the point of the administrative process. That was the opportunity for both sides to sit down and look contextually at the record as a whole and say, well, now, wait a minute. Past the 8th, we had passive suicidal ideations on the 9th and the 10th. We have no addressing of underlying conditions that led to this until at the earliest in the record, February the 12th, in a session with Dr. Schwarma. That's why Menninger fully supported the full stay of the 21st. And in fact, it was the family financially that just couldn't afford to go past the 21st that decided, March 21st that is, decided to leave March 21st at the conclusion of the COMPASS program. The records reflect that Menninger actually wanted her to stay beyond the 21st, felt that she needed it for risk of patient deterioration.
But back to February 10th, and just in terms of the independent review's determination that that was the day,
Sure.
I mean, to the extent that he didn't provide any rationale, you could also say if the date's arbitrary, it could have actually reverted back to February 5th. In other words, sort of, if I follow your argument, saying that it should be extended, well, you could just about as easily say it should be cut back as well. I mean, is that right?
You could have cut back to the 5th, you could have cut back to the 8th or the 10th, because in either event, all 3 dates were arbitrary. All 3 dates bore no relation to the actual record.
And so, assume arguendo, if the 10th is arbitrary, I mean, you can sort of chip away at that, though, because on the 11th, I think it was, she was promoted, so to speak, to level of responsibility 2, correct? By the 21st of February, she's out on a day pass for several hours or most of a day, correct? I mean, wouldn't that militate in Blue Cross Blue Shield's favor as well?
It would militate in their favor on the 21st for the day pass, but this is where I take issue with those arguments. Because, and this is what the district court talked about when the district court used this language of seizing upon any indication in which to justify their decision. I love that language of seizing, because here's what actually happened on the field pass. If you look at the record, and I want to make sure I cite this correctly, when she had that field pass, she goes with her family to go shopping that day. As soon as she comes back, she begins having mood swings, she begins feeling bad, she begins having, again, on the 23rd, after the 21st, on the 22nd and the 23rd, once again, passive suicidal ideations, feeling hopeless and frustrated that I don't understand why I cannot realize the source of what the problem is. So what the plan says is, look, she went on a field trip and she had a good time. I admit that. She did. The problem is, and this is the problem with the several comorbid disorders that exist here, you have a good moment, or you have maybe even a good day, and you cherry pick that, and you don't look at the long-term effect of this. They look at the field trip and ignore the very next day, which had passive suicidal ideations combined again with impulsivity. So I will admit, Judge, that of course she had a field trip. What I don't admit is that as of February 21st, that this particular patient was in any condition to be released without, to a lower level of care, without patient deterioration.
Well, but even back up to the 17th of February, she was promoted to a level of 3 responsibility, correct? And that level of responsibility, or that classification, obtained till she left Menninger, correct?
I believe that's correct.
Well, again, that's another data point, though, in terms of something that Blue Cross Blue Shield could rely upon.
Well, Blue Cross could have relied upon that data point on the 17th, but they didn't. There simply was no evidence in the record at all for why they chose the 10th. I think my argument would struggle if Blue Cross said on March the 7th or March the 8th, we're cutting off treatment, because that would bear some indicia of rationality to the record. In this case, the only rational connection we seem to have is between the MCG's optimal recovery course, which the MCG's optimal recovery course, this is in the record 525, is 5 initial days, and then 4 to 7 days. The MCG has placed this arbitrary date, regardless of person, of about 9 to 12 days to fix the human mind. And when you look at what they originally approved here, it fits squarely within that time frame, 11 days. That's what they approved, 11 days. It took Dr. Gerges to extend that past the optimal recovery course but only to 15 full days of treatment rather than the COMPASS program's actual design. And when I look at the 5th, and I look at the 8th, and I look at the 10th, there's simply, forget substantial evidence, there's not even a scintilla of evidence with the ideations that are happening to support any rational connection to cutting off treatment. So it forces one
But that's
to-
also what Menninger was requesting up until the point of the appeal after the fact. Menninger had only requested through February 10th, correct?
Menninger had only requested up to February 10th because that my appreciation is, and I don't want to speak out of school, my appreciation is that's the method in which they have to apply. They apply in certain tranches of treatment going throughout the entirety of the program, sort of justifying the acute inpatient nature as they go until such time as they complete the program. Now, of course, once they were denied on the 10th, there was no point in committing those individualized every couple of days assessments. There was one large final appeal at the end of the entirety of the treatment, which gave everybody the benefit of context to see the necessity of this for the entirety of the time. Now, I did want to, Judge Oldham, to your question you asked about the standard of review, my counsel's comments on that I think are remarkable. I think on the Nord case, the Nord case makes clear the administrator need not defer to the opinion of the treating physician. No doubt, we understand that even though in this case, the treating physicians were unanimous, not nearly unanimous, but unanimous that all of this was medically necessary. But it cannot, quote, discount the near unanimous opinions of treating physicians without explanation. I think the idea that Blue Cross Blue Shield can simply ask this court to look at the record, but without conducting any analysis, rubber stamp it, would turn abuse of discretion into simply no review. It wouldn't be discretionary review, there'd be no review. And I think that that is a misreading of what the standard is. I do not suggest for a minute for this court that the standard is not abuse of discretion. I do think there is discretion. The problem is that discretion was abused in this case when the cutoff dates bear no rational connection to what was happening to her treatment in the record. And I think to make a statement that you simply do not even have to conduct an analysis. You take Blue Cross's proffered reason, almost reminds me of an employment context. You take the pretextual reason and you conduct no analysis. You just simply accept that reason. It flies in the face of even what the district court did. I'll direct you to page 35 of the appellant's brief. Page 35 of their brief, they state, this is the appellant's brief. They state, we think the district court got it right when they applied abuse of discretion. We think they got it right when they rejected my argument. In fact, I've been arguing for quite a while the MCG I don't think is appropriate in the mental health context. And I talk a lot about that in my brief, but the appellants say district court got it right by rejecting my argument on the MCG, got it right by rejecting my argument the record was incomplete, by not retaining all the records from these prior suicide attempts. The district court got it right in applying the key question in this case, is there substantial evidence? And finally, they say, here's where the district court veered off its path. When it analyzed the evidence, it got it wrong. Well, the alternative way to state that is they just don't like the result. But to state that the district court should not conduct at least a bare minimum review of the medical records to determine, is this, and I think the district court used the word some, is this a scintilla, or does this rise to substantial? And that is the key question before the court, in which the appellants just simply disagree. But I've spent 12 minutes without giving you the brief factual recitation that I wanted to.
So just to follow up, though, I assume, let me know if you agree with this, it is possible for a case to have substantial evidence supporting either side's theory.
That could very well be possible.
Right. And in that case, do you agree that in that case we would have to agree with the plan and find that there's no abuse of discretion?
If both sides are deemed by the court to have substantial evidence.
If there's substantial evidence to support both the patient's preferred care and the plan's care decision.
I think in that case, Your Honor, the tie would have to go to the plan, but that's not this case. This particular case, when you look at the cutoff dates and you look at the decisions made with no rationality provided, there simply wasn't, again, as I've said, don't analyze this as substantial evidence. There was virtually no evidence. In fact, I do want to talk about that before I do the factual history. Let me talk about what some of the things these doctors looked at when we talk about what the sum evidence is versus substantial evidence. When justifying cutoff and why this was not needed as inpatient, here's what two of their doctors, which have been criticized in other courts around the country, here's what two of their doctors talked about. Dr. Allen, he talked about the fact that the reason this was no longer needed was because the patient was having no psychosis. I need not remind this court that MP was admitted for major depressive disorder without psychotic features. She never had psychosis. She never had psychosis on day one. There simply was no rational explanation to say that because she had no psychosis, she's suddenly able to be released. Dr. Stock fares no better. Dr. Stock looks at Dr. Allen also looked at one additional thing. He looked at parental support. He said, well, the reason why that this acute care is no longer needed is because her parents were supportive. Again, her parents were supportive, and the record confirms this. Her parents were supportive the entire time of the treatment. In fact, it can hardly be said in the record that MP voluntarily went to Menninger. She believed her case was hopeless. She believed after 4 years, which I was going to talk about in the factual history, from 2012 to 2016, the family in this case engaged in very conservative treatment. Their first step was not to Menninger. There were 4 years of 13 different psychiatrists in this case, 20 different prescribed medicines, and 2 different neurologists, all of which failed and led the family to their last resort of Menninger, of which that's why all the treating doctors supported such a stay, because of 5 prior failed acute inpatient hospitalizations. After each and every hospitalization in the Lake Charles area, shortly thereafter, there was another committed attempt. It was imperative to address the underlying issues, or this particular member was going to keep using planned dollars on some of the most expensive kind of care there is, which is emergent care, rather than addressing the underlying need. And in this particular case, for this particular patient, MP has never been back to the hospital, and I believe now has graduated as a chemical engineer and is working in the state of Washington, I believe. So by addressing the underlying issues, the issue was solved. Now, why is that important? When they talk about parental support, the parental support was a constant. That didn't change when her admission was justified on January 26th versus why suddenly it wouldn't be justified February 10th. Dr. Stock, he gives us one of his bases as to why she no longer needs acute care, that she was tolerating her meds well. Well, let's look at the record. What were the meds that she was taking? As of February the 10th, the meds taking Benadryl, Tylenol, Excedrin, and milk of magnesia. You can hardly say someone's tolerating their meds when they're taking basic headache medicine. They did not begin to administer the SSRIs in this case, such as Zoloft, which did require subsequent administration and changing of the dosage. They did not begin to even dole out that medicine until the 10th. The day coverage was cut off was the day they finally began administering the SSRIs that required her.
Well, but the point that keeps turning around in my head is that administering Zoloft is not, I mean, you don't have to be in acute inpatient care in order to be administered those meds. There are step downs, residential, for example, and even less than that as it's warranted. And so it's not a matter of all or nothing here, right?
Well, I think that's a fair point, Your Honor, except that it doesn't work in this particular context, and here's why. I think you could administer Zoloft to another patient and do so in a less restrictive setting. The reason why this particular patient, in these unique facts, needed this kind of restrictive care was for the following. And she's not just, as the defense says, she was admitted for bipolar disorder. That's simply not the case. Her diagnoses were as follows: major depressive disorder without psychotic features, severe impulsivity, substance abuse disorder, generalized anxiety disorder, and then, of course, the bipolar disorder. Now, what makes that so dangerous, and what Dr. Davidson talks about, is that the comorbid substance abuse disorder meant that whenever there was that passive suicidal ideation, or even a negative reaction to drugs, or like the Zoloft, or even if there was nothing like that, a field trip that triggered negative thoughts, the impulsivity combined with, and in fact, 2 of her prior suicide attempts were, in fact, through drugs or alcohol. That was one of her chosen means to try to end her life. If that were to happen, the impulsivity meant that she could move on the matter very quickly. It wasn't as though it would take any forethought or foresight. If this particular thought with her particular mind ratcheted as quickly as it had in the past, there would be no one around, certainly in a lesser care setting, as Your Honor is talking about, which I think works for some patients, sure. But for this particular patient, as Dr. Davidson talks about, what made her situation just so dangerous, I think is the word that she used, I want to get it right, opined that, quote, MP's profound depression was complicated by a serious substance abuse problem that increased the likelihood of a completed suicide. That's at the record 7525. So Dr. Davidson understands that it's the comorbidity that creates the patient risk. On top of that, to your point about the lower level of care, lower levels of care had been tried. In fact, even restrictive amounts of this degree had been tried on 5 separate occasions. The prior hospitalizations for this particular patient for the course of that 1.5-year time period were, and Blue Cross Blue Shield, though they don't have the records from these particular hospitalizations, they do acknowledge that there were claims made for these hospitalizations. There were hospitalizations for 4 days, 5 days. In one case, there is hospitalization at Longleaf, which there was no work on any kind of underlying conditions, for 18 days. Now, at first glance, you look at inpatient treatment for 18 days at Longleaf, and you say, well, that's a situation where they went past the MCG guidelines. My response to that would be, if you had seen Longleaf and seen their approval for 18 days of acute inpatient treatment, and you saw that it did not work, why on earth would you think that 11 or 15 days would do the trick here? If anything, more time would be needed because it had been tried in the past and failed. But the simple fact is, they may not have known that a lower level of care wouldn't work because they didn't bother to get the records from the lower level of care. Though, because I think in their briefing they argued that such was irrelevant. But I want to conclude, and I think that this court should affirm the district court by looking at simply what Dr. Gerges himself, the independent reviewer himself, stated, that the member had shown a remarkable change for the better since going to managers. The member state had dramatically altered the course and direction of her illness in a way that local hospitalizations were not able to do. Without providing any explanation for going past 5 days, it is that rationale that should stand, and I implore this court to affirm the district court. Thank you, Your Honor.
Thank you. We have your argument. Mr. Martin, you've reserved 4 minutes.
Thank you, Your Honors. Excuse me. To level set, if this were a de novo review situation, the weighing of the evidence and the debate over the level of care would be pertinent to this court's review.
Well, Mr. Martin, you told me in your topside argument, you told me that the way that we're supposed to look at the facts is that we look for evidence that supports Blue Cross Blue Shield and we ignore everything else. And that was startling to me because I'm aware of no area of American law that works that way. But you told me that in ERISA, it does work that way, and you cited, for example, the Black and Decker decision from the Supreme Court. So I'm looking at the Black and Decker decision. This is page 834, unanimous decision for the Supreme Court by Justice Ginsburg, where she writes, plan administrators, of course, she says, may not arbitrarily refuse to credit a claimant's reliable evidence, including the opinions of a treating physician. So I ask again, why is it that in ERISA, we just straight up ignore everything on the claimant side and we only look for evidence on the Blue Cross Blue Shield side?
So, Your Honor, the evidence should be considered, but in evaluating whether the record meets more than a scintilla and a rational decision, the court is entitled to and should look at the evidence that supports the administrator's decision. That's what we're advocating for. That comes from this court's precedents.
But not the Supreme Court.
Oh, no, the Supreme Court says the same thing. It has to be considered, but in the end, once that happens, what do you look at? You look at the evidence that supports the administrator's decisions in determining whether there is more than a scintilla and it is on the path of rationality.
The thing I'm struggling with is ERISA in section 1133, subsection 1, requires the plan to offer, quote, specific reasons, right? So you can't just say deny.
Right.
You have to offer specific reasons. And then we are supposed to review, I think, the same way we would do it for an administrative agency, which is to look at the record and figure out, if the decision maker did something that was rational in light of all of the evidence, not just cherry picking the facts that would support BCBS.
Yes, Your Honor, and if you look at the decisions that were made here by the 4 independent physicians that reviewed, you're going to see references specifically to MP's medical records and her conditions to validate the decisions that they made. That starts with Dr. Kajewski, it goes through Dr. Stock, it goes on to Dr. Allen, and finally to Dr. Gerges. Each one of them gave reasons specifically anchored in MP's records as to why they were making the decision that they did. And there were other data points in this record, as we've talked about, that referenced and made the 10th a rational date to pick if we're talking about more than a scintilla of evidence. And as to MP's condition on the 10th, the records are clear that there is substantial evidence to validate selecting that date. So we can go, even considering what the Menninger folks had to say and the treating doctors had to say. She was alert, she was goal-directed, there were no suicidal ideations, she wasn't a safety risk. Her level of responsibility was, in effect, stepped down, but that's stepping up. Beyond that, there were indications that she hadn't had any suicidal thoughts, no attempts. She was involved in her care. There was no need for 24-hour surveillance anymore. In other words, there was substantial evidence in this record that the reviewers looked at that could lead them to the decision they made. And in a discretion review, that's sufficient to carry the day.
Thank you. You have your argument, and the case is submitted. I want to thank counsel again on both sides for their willingness and interest in appearing for us today. It's
Thank
good
you,
to
Your
see
Honor.
counsel again after a long period.